Okay, well, welcome folks joining us live, and those of you who will be watching later via recording as well. Really appreciate you tuning into this series focused on access to justice, put on by law schools in the Pac-12. My name's Scott Skinner-Thompson. I'm a professor at Colorado Law School, and yeah, it's my real pleasure to be representing CU tonight. Before I get started, I want to thank Dean Elizabeth Warner at the University of Utah for organizing this series. Also, thanks to Charlie Stewart at Utah for facilitating the event. And thanks to my associate dean, Fred Bloom, for helping me get connected to this program. And thanks to all of you for joining. Today, I'm going to be talking a little bit about a project. Sorry. Called Identity by Committee, that looks at the regulation of transgender students and gender variant students in public schools. And the presentation builds off an article I'm writing by the same title, and that'll be forthcoming in the Harvard Civil Rights and Civil Liberties Law Review. And it represents obviously some of my work, but also the work of a host of tremendous research assistants that I want to acknowledge and thank, as well as Jane Thompson in our in the CU library. So the animating concerns about this project are, as I mentioned, I'm looking at the regulation of gender in public schools, and the mechanisms that have been developed, even in purportedly progressive school districts, are incredibly Byzantine, incredibly complex, and as I hope I'll demonstrate, ultimately inaccessible to very, very few students who are simply trying to live their lives. And of course, structures for regulating and policing gender are not new, and they're not limited to the school context. They pervade our society, whether it be literally from the moment we're born, sometimes before we are put into boxes based on a few inches of flesh here and there that may or may not accurately represent who we are, or who we want to become, or the identities we want to explore. And again, my project is focused in particular on the structures that have been created in the school system, purportedly to enable transgender students to live consistently with their gender identity, but may be causing harm to such students. So in addition to documenting the procedures that students have to go through to live consistently with their gender identity, I am also going to talk a little bit about whether or not how we got here, whether or not these bureaucratic structures, these committee structures, are a product of the way we've thought and talked about gender and gender identity, and whether or not there are other ways of thinking about it, in particular thinking about gender as expressive or performative, that might yield greater freedom for gender varying students. So as it stands, there are two approaches to regulating gender in school, and as you'll see, each school in each state does it differently, but these are two broad approaches. And the first approach that has gotten a lot more attention, and probably rightly so, is what I call the no freedom approach, wherein schools or states say that a student will be classified as a particular gender based on the sex they were assigned at birth, or sometimes labeled their quote unquote biological sex, even though that's not a single thing and not a coherent concept, given that many aspects of our physiology make up or can contribute to our gender. And so some high profile examples of this that have been challenged are Gavin Grimm, who challenged his exclusion from the boys' restroom in his school in Virginia, and he successfully challenged that in the federal court under an equality framework. More recently, this last legislative term, many states throughout the country either proposed or enacted bans on transgender participation in youth in school sports, and Arkansas even went so far as to ban transgender students or transgender youth from accessing medically necessary health care. And here I've pictured the name plaintiff Dylan Brand in a lawsuit challenging that medical exclusion, which at the moment has been stayed by a federal district court. But the other approach is what I call the committee approach, and it in essence provides that, okay, in theory, gender variant students, you can live your life consistent with your gender identity, and we recognize that your sex assigned at birth may not be accurate and doesn't control your destiny, but we have enacted a whole host of procedural and substantive requirements that we're going to use to police and regulate your gender, to make sure you're actually the gender you know you are and that you tell us you are. And so in terms of procedural requirements in these committee jurisdictions, which again are jurisdictions we might think of as quote unquote progressive, students, in order to live consistently with their gender identity, accessing bathrooms, and in particular accessing sports, may have to present documentation and be evaluated by a host of purported stakeholders, including medical doctors, mental health professionals, teachers, school district administrators, their parents, the broader community, meaning other students and their parents. And sometimes there's even formal adjudicative bodies set up to evaluate and judge what a person's gender is if it is challenged. Sometimes these policies were unwritten, sometimes they're made reactively. That is, schools may think that they haven't thought proactively about the existence of transgender children, which of course existed forever. But increasingly, the policies are being put to paper. And here I'm just going to highlight some examples with the intrepid research assistants that I alluded to earlier. We looked at the policies governing transgender access to sex segregated spaces, bathrooms, and sports in every 50 states, in all states, and each state's largest school district. And we've coded and created a schema that documents the different procedural and substantive requirements that students must go through to live their gender. So here's an example of the, what I colloquially refer to as the committee structure, though some school districts actually have formal committees. So South Dakota High School Athletic Association requires schools to collect written support and/or verification documents from the students' parents and healthcare professionals, and then submit that documentation as part of a quote unquote transgender application. You literally have to apply to be transgender. That application is then referred to an independent hearing officer who makes a decision about whether or not the student is who they say they are and can participate. Similarly, the Arizona Interscholastic Association requires students to submit evidence of support from their parents and guardians, school administrators, and healthcare providers, with the ultimate determination of eligibility determined by a so-called quote unquote gender identity eligibility committee. Now, these committee structures are actually in some ways, they all vary to certain degrees, but in some ways they mimic or build off some model policies that have been put forward by LGBT organizations. And now, to be clear, I think that many of these policies, whether put forward by an LGBT rights organization or not, are motivated by a very good purpose, right? Which is designed to give students greater freedom. And so I'm not in any way impugning the motives of these policies, but I am very interested in whether or not they're actually achieving their goals at scale. And so GLSEN and the National Center for Transgender Equality have a model policy which cautions that while schools should avoid requiring any sort of proof regarding a student's gender identity, they nevertheless seem to suggest that the school does have some sort of legitimate role in verifying a student's gender identity. And then they say, that in practice, it's not difficult to do that. Similarly, in a best practices guide developed by a consortium of LGBT organizations, they advocate creating a gender transition plan that incorporates a lot of these stakeholders that I've been discussing. Okay, so those are the procedural requirements, the stakeholders that may be involved, and there are also some substantive requirements. So a lot of these policies don't require you, for example, to live. You're not relegated to your sex assigned at birth, but there are still some limits in terms of who can and can access sex segregated space. So one requirement that appears frequently is that the student consistently identify with a particular gender in every context and for every purpose, suggesting that gender needs to be fixed and constant in order to be legitimate and leaving no room for expression or exploration. Other policies give credence to the faulty notions that students may be quote unquote gender imposters, requiring a student's gender to be accepted if it is sincerely held, bona fide, or genuine, when there's really no evidence to suggest that there are people who go around pretending to be another gender for sinister reasons. Other policies, in terms of the language they use, also cast a doubt on the student's gender, saying it's the gender that they assert rather than it's the gender that they are. Put differently by Jack Halberstam, rumors of the demise of hegemonic sex and gender systems have been greatly exaggerated, and sex and gender is still highly regulated, particularly in the school context. So what are the what is the human cost of this regulation? The first cost is that it erects a substantial barrier to identity freedom. While I mentioned the goal of these bureaucracies is freedom, they can just as easily stifle. The questions and procedures emerge from an expressed skepticism regarding trans youth's existence, and in essence ask students to prove themselves, something that's not done in almost any other context. Moreover, by rewarding those who consistently identify in a certain way, the school policies reward and enshrine a particular kind of gender identity, often along immutable binary lines. Finally, these social systems, this committee process, it requires immense social capital. I mean, imagine how much courage it takes for a student to merely recognize in themselves and identify vocally to friends and family that they're transgender. That already is a huge undertaking. Now, to make matters more difficult, they have to navigate these bureaucratic processes. And to do so is not intuitive. It may require parental support, and the parents may not have the know-how or the time and physical resources to navigate these processes as well. So on a practical level, the committee structure is inaccessible. It also creates real threats in terms of invasions of privacy along a couple of different axes. First, in terms of data collection, the committee process represents an immense data collection effort. And here I just used the gender transition plan that I referenced earlier, created by Gender Spectrum and some other LGBT organizations. It contains extensive questions that students are supposed to answer. The nature of the student's transition, how urgent it is, the list of staff members who will be present during the initial planning meeting, the specific information that will be conveyed to students more broadly, which students will be provided the information, any sort of information that will be shared with the community more broadly. And while these plans purport to, try to maintain confidentiality, this information gathering itself is a privacy risk. In addition to that data gathering, there's also disclosure risk, and that occurs when there are systems wherein other members of the community can challenge a person's gender. And I'm sure some of you are familiar with the YouTube videos of school board meetings where trans students and those opposing them are engaged in, just extremely visceral and for the students demeaning conversations about their life. Until recently, just this year, the Washington Interscholastic Athletic Association had in their policy allowed people to basically challenge people's gender, in which case it went to a hearing, and the hearing was confidential, but it was still quasi-public because people could challenge it. Similarly, while the National Education Association guidance advises that schools should accept a student's assertion of their gender and not require any particular substantiating evidence, they nevertheless suggest that there be a process for evaluating credible challenges to what the NEA labels the student's asserted gender identity. Moreover, and finally, and by way of harms, there are also pernicious distributional impacts to this system. Structural racism and poverty are going to make this process less accessible to students who are working multiple jobs and don't have the discretionary time and social capital to navigate this process. And we've seen similar phenomena in the disability context, where to get services for a student with living with a disability requires immense efforts, the development of a plan, again, all well-intentioned, but not ultimately very accessible. Moreover, queer students of color's identities are less likely to be read as legible and valid by school administrators in the first instance, and that's perhaps not surprising given the degree. And again, reference back the only pictures, I apologize, that this slideshow will have, but of those two plaintiffs represented by the ACLU challenging laws in Arkansas and Virginia, white plaintiffs who have often been centered in discussions about trans youth. So all told, and here I'm borrowing from Professor Jules Gill Peterson and their fantastic book, The Histories of the Transgender Child, this process operates as radical skepticism and verification in the best instances. As put by Gil Peterson, adults, including parents, so-called interested observers, or even allies and advocates, tarry within the dangerously limiting circumstances of a system that continues to assay the value of trans children's being in terms not of their humanity and personhood, but via questions absurd in their abstraction, for how they ask us instead to wonder if trans children prove something about the biological basis of sex and gender. In short, borrowing here from quite a different source, Yusuf Islam, in his song Father and Son, from the moment I could talk, I was ordered to listen. And I think that that aptly describes what this process is doing to transgender children. They're finding their voice, trying to express their gender identity. And these committees are in essence, telling them to listen and to comport with certain requirements. So how did we get here? How is this the best case scenario that the LGBT advocacy community has, in many instances, come up with? I think we got here in part based on the way that society has often thought and talked about gender and gender identity. And there are three, somewhat overlapping but distinct ways of thinking about gender that have been developed. The first is the so-called biomedical mental model. The second is the social model. And the third and final is the expressive model. And as I'll explain, the first two models have predominated, while the third model has received less emphasis as of late. So what's the biomedical mental model? In essence, it's the nature model. The argument that, and again, there are variations within this model, right? The no freedom approach to trans students is a biological model, right? They say sex assigned at birth, external genitalia, that governs. But the biomedical mental model covers more than just that, and indeed is encapsulated in a lot of the identity by committee approaches that I've been talking about. So other variations on it provide that gender is innate, fixed, and biological, but the source isn't necessarily one's external genitalia, but one's internal sense of gender identity, but that gender identity is innate, and bringing the body into alignment with that identity can help alleviate distress caused by social misrecognition. So again, emphasizing the innateness and emphasizing something physiological, and also emphasizing physical interventions to help as a palliative measure for quote unquote gender dysphoria, or the discomfort that can arise when you are misgendered. This path can be freeing for some. Some people find themselves in this path, but it's still stifling for others, particularly those who don't comply or beautifully challenge the gender binary, and for those who do not desire or cannot access, for practical reasons or health reasons, certain physical interventions. And I think that this biomedical mental model still is very prevalent within discourse of gender and gender identity. If you look to WPATH, the leading health organization on transgender health, it's replete with emphasis on this biological mental model. And what that does is enshrine the gatekeepers, right? It enshrines the gatekeepers, the mental health professionals, the physicians, who we see also being enshrined, not just in the medical care context, but in the school context, as determinants of someone's identity, not just providers of a service that might treat dysphoria. There's also the so-called social model, put glibly, nurture. As some developmental psychologists have put it, gender is made, it's also born, right? So it's made, nurture, it's born, nature. And the social elements are also multifaceted. In the first instance, and perhaps most simplicity, the idea is that, well, okay, environmental factors influence the development of gender, and at the very least influence how we express gender or understand gender, right? Like the sartorial choices we make, there's nothing innate about that, right? That's all just socially conditioned, and is a product of what we have of learned behavior. Social model comes into play to the extent that the social performances and transitioning are also used to test and diagnose whether someone is trans. So in the medical literature, the doctors may say, okay, live consistently as this gender for a year, and then we'll know you're trans, right? And so living consistently with the gender is used, the social transition is used as a diagnostic tool to make a determination about someone's identity. And as I've noted multiple terms, transitioning can be palliative in terms of gender dysphoria. No less than the medical model, the social model helps enshrine these gatekeepers that I've been talking about. So finally, we have the expressive or performative model. And the expressive or performative model suggests that gender, rather than being anything biological or only biological and only social, is also created and given meaning through our individual and collective performances. And so as trans historian Susan Stryker puts it, rather than being an objective quality of the body defined by sex, physical characteristics, gender is constituted by all of the innumerable acts of performing it: how we dress, how we move, how we speak, how we touch, how we look. Gender is like a language that we use to communicate ourselves to others and to understand ourselves. And make no mistake, this expressive component has received emphasis by some trans activists, including Leslie Feinberg and queer theorist Judith Butler, but it's also been downplayed. Some worry that deeming gender expressive or performative suggests that it's authentic, but that's not the purpose of this model. It's not in any way saying that gender is inauthentic, but that it is potentially dynamic. And so I think that renewed emphasis on this expressive understanding of gender. And again, I know, I'm not suggesting that any one of these modes of understanding gender is in any way more or less true. I'm actually highly agnostic about that. I think that there's elements to truth to all of them, and I'm interested in which model or way of understanding gender leads to the greatest emancipatory potential for people. I think that anybody. That gender is really difficult to understand, and there's lots of disciplines trying to understand it. But anybody that pretends to have a complete understanding of it is, as trans scholar Florence Ashley puts it, liar, liar, pants on fire. And I agree. And I think that it's more important that we think about which frame leads to the greatest emancipation. So in terms of doctrine, I am a lawyer, so I need to talk about doctrine a little bit. In terms of doctrine, I think that there are a few benefits that will flow from a renewed emphasis on the expressive components of gender. And first, I think it's important to underscore that there is a robust doctrine under the First Amendment embracing symbolic speech as a form of expression. So the court has recognized, for example, that wearing a black armband in the context of the Vietnam War is expressive of dissent, right? And they're particularly attuned to social context. A black armband in the abstract means absolutely nothing, but in the context of Vietnam War, it meant a whole lot. Similarly, the Supreme Court has recognized that gender and sexual minorities' identities themselves, separate and apart from any sartorial choices or clothing choices they're making, can be expressive. And indeed, they've used that expression as a reason to permit certain expressive groups to exclude queer people because it would taint their message. So in Boy Scouts versus Dale, the Supreme Court said, well, Boy Scouts, you have an expressive message. And so, allowing a gay person in would diminish that message because their identity is expressive, so you can exclude them. Okay. Similarly, in Hurley versus a case dealing with a St. Patrick's Day and parade in Boston, the court said, okay, St. Patrick's Day parade organizers, you're doing something expressive, so you can exclude gay people because their presence would be expressive and it would dilute your message. And so I think there's actually great doctrine suggesting that identities, non-normative sexual and gender identities are expressive. And critically, for the First Amendment analysis in the schoolhouse, you may, for the lawyers out there, be familiar with the Tinker v. Des Moines case, which is the black armband case I was referencing, where the court, basically said students don't shed their free expression rights at the schoolhouse gates, but and they are allowed to express themselves so long as they are not disrupting the educational environment. And a further line of cases have said that students' negative reaction to student speech is not a basis for regulating it, right? Or else that would give a heckler's veto. So the disruption that may be caused by someone being uncomfortable by the existence of trans people is not justification for diminishing the expression of their gender identity. They challenge the heteronormative and cisnormative environment. They don't disrupt the educational environment. So I think there's a strong basis for concluding that these identities are expressive and covered by the First Amendment, that they're not disruptive to the school environment. And then the third step in the doctrinal analysis would be to analyze whether or not the committee structure I outlined infringed on their expressive freedom. And I think that there's little doubt that it does. They are being targeted for their expression. Not all people that express their gender in a certain way are subject to these regulations, right? If you can express your gender in a way that's consistent with the sex you're assigned at birth, you're not subject to these regulations. And so there's sort of viewpoint and content discrimination. Moreover, it operates as a form of prior restraint. You have to go through these committee processes before you can express yourself. And so I think for those reasons, there's strong arguments that courts would conclude that this is an infringement on the student's gender expression. So now that we know it's expressive and we know that it's not disruptive and that the regulations infringe on it, the next step in the doctrinal analysis is to examine whether or not the regulations can survive strict scrutiny, whether they're justified by a compelling government purpose and narrowly tailored to meet that purpose. And I think the answer to that is no. And so what are the potential government purposes that might be and that have been advanced for regulating students' gender identity? One that is often put forward is privacy, right? And make no mistake, I'm a huge privacy advocate, but I think that these privacy arguments in courts are seeing this are often not terribly robust. So the privacy arguments raised against trans students' existence often fall into a couple of categories. First, parents of other students will say, look, well, I don't want my child to be exposed to genitalia other than what they have, and I don't want people with different genitalia than theirs to see my child's genitalia. Assuming that is a important government interest, I think that these gender regulations are in no way necessary to achieve that interest. Increasingly, architectural design solves all of these problems, right? Like bathrooms are being designed with privacy in mind, private stalls, and there's no reason why a cisgender student's uncomfortableness should require a trans student to be excluded. If the cis student is uncomfortable, they could go to a private place. Put differently, segregation isn't the solution here, but creating private space for whoever wants it is a very easy architectural solution, and you don't even need to build a wall. You can just draw a curtain. It's not rocket science. Moreover, the other arguments that are often raised that deal with sex-segregated sports, and in particular concerns about female athletic opportunity. And undoubtedly, statutes like Title IX have played a critical role in creating space and making sure that there are opportunities for women's athletic competition, and that is important. The question is, do the existence of trans women threaten that? And I think that the answer is no, for a few reasons. First is that sex is actually a very poor proxy for size and athletic ability. The average, the range of size within any particular sex, okay, at the high end and low end of height or weight for people assigned a particular gender, is much greater than the averages difference between any two genders, which is to say that if you allow boys to play on the football team, you're going to get petite boys, right? and that's maybe dangerous potentially in a contact sport. All of which is to say, sex is a poor proxy. Moreover, bodies are all different, and not all bodies based on their gender are going to be good at a particular activity or not. Finally, I think while cis women's athletic opportunity is important, it's important to question whether or not the goal is opportunity to participate and compete, or are you guaranteeing victory? So even if trans girls became really statistically dominant force in youth sports, which I think is highly unlikely, is there exclusion meaning that other people don't have the ability to compete? No, they don't, and nobody has an entitlement to win. And so I think for those reasons, among others, the reasons proffered for this gender regulation fail. Finally, I think any sort of I started by this is somewhat a comparative project, right? I'm looking at these discursive models. I'm also comparing to other doctrinal arguments that might be available. So why not rely on equality arguments? We've seen equality arguments prevail. They prevailed in the Gavin Grimm case that I talked about. They prevailed in the Title VII employment discrimination case decided by a conservative Supreme Court in the last couple of years. Why not use those? And I think they are limited in a couple of respects. First is they tend to rely on and privilege the gender binary, which is already excluding a whole host of gender privileged, already excluding a bunch of gender variant people. And I also think they tend to prevail when you have these sort of model plaintiffs, the clean-cut white trans student who complies with gender norms other than being assigned the wrong sex at birth, but are unlikely to be as capacious and effective for those who don't fit traditional molds. Whereas I think the expressive dimension creates a whole host of freedom. And indeed, the more a student challenges the norms, the more likely their identity is to be understood as expressive and protected as speech. Finally, I want to talk a little bit about discursive dividends, and this is related to my final doctrinal point too. I think that there's this fear of gender exploration. There's this fear of gender play, and we see that in the committee structure, right? When they're getting rid of sex assigned at birth, but they still require consistency. They want it to be bona fide, and they don't want youth to just be trying on different ways of knowing themselves. And I think that that is suboptimal. I think that we are all living within the constraints of these social norms, whether we want to or not. We are products of the way we have been conditioned, and I think that a true emancipatory agenda for these children and for all of us would encourage and try to create space for them to brush up against the norms, challenge them, recreate them in really beautiful ways that will have dividends, not just for gender freedom, but I think for and gender freedom for students, but will also shed light on our shared humanity and help break down barriers and divisions more broadly, and allow us to just let each other live and love each other for our evolving differences, and not for some category that we were relatively arbitrarily assigned at birth. So that's all I have by way of prepared remarks. I'd love to hear from the audience. It is recording, but my understanding is the YouTube video will not have the question and answer portion broadcast, so you should feel if you're worried about that, don't be. If you want to ask a question, just type it into the chat and I will answer it. I see, yeah. I think the way we're doing this is just type it in the chat, and then I will answer it. I think everybody's muted. You can send it just to me or to everyone, whatever you prefer. Okay, so I have a question. Do you think the cases that use anti-sex discrimination laws to attempt to thwart gender discrimination can incorporate the expressive model, or do you worry it could further ingrain the biomedical model? I think this is a really good question, and I think that it gestures to an important point, which is, I may be creating artificial silos or categories between these legal tools. And I think the short answer to the question is yes. I think that expression can be incorporated into an equality framework. And I think one of the early sex discrimination cases decided under Title VII, which prohibits sex discrimination in employment, gestures to that. And that's the case of Price Waterhouse versus Hopkins. In that case, Ann Hopkins was up for partner at the accounting firm of Price Waterhouse and was passed over. And there was evidence in the record that Hopkins was passed over because of her non-normative gender appearance. In essence, she acted, according to the partnership Price Waterhouse, as too masculine. And so the Supreme Court said that this was a form of cognizable sex discrimination and a equality-based argument because it relied on sex stereotypes, right? That Hopkins was being punished for her failure to comply with stereotypes about her gender. So I do think that the models can bleed into each other, and that the question is absolutely right. Like, not only is there a potential First Amendment argument here, but you can imagine the expressive dimensions of gender giving weight to the sex equality arguments that could be made in the Title IX or equal protection context in schools. That's a great point that I'm going to add to the article. Thank you. Okay, I'm going to give it till 7:45, and if nobody else chimes in, we'll bid you all adieu and a lovely evening, and really thank you for tuning in. Oh, we've got a question. It's coming. Good. So another great question about the limits of individual litigation as a strategy and whether there are other strategies. I think it's a really important question. I mean, I not only are these committee structures barriers in and of themselves, but we've all encountered barriers in our lives, right? And often the response is, depending on how grave it is or our resources, we just try to overcome it on ourselves. Bringing a lawsuit is another barrier. And so that's why a lot of the cases that are brought by movement organizations, incredibly important litigation. I think that movement litigation does play a critically important role in educating us. I mean, we've seen that in the gay rights context, same-sex marriage. These cases, they're about the individual client, but they also tell stories. But the stories they tell are also limited, right? Like the Edie Windsors of the world, the Obergefells of the world, paint a very narrow picture of the queer community. So we're not getting a full social understanding of the problems. And so I think we need on the ground local advocacy at the school board level. And that's why, again, I really laud the LGBT organizations for making these policies. I laud the school districts that have implemented them. That is in reaction to a lot of hard-fought grassroots activism. And so what I'm gesturing to is that represents progress, but can we go even further? And I think, as it pertains to the question, it's going to involve litigation, but it's also going to involve individual change on a school district by school district level, which is going to require, intensive mobilization. All right, since we had one question, I will extend the clock to 7:50. Any other questions out there? Okie dokie. Well, I appreciate all of you joining in, and thank you very much. I recognize many of the names, so look forward to catching up with you in due course. Thanks so much for tuning in on this Tuesday night. Talk to you soon.